Welcome to the channel. Hit the like button, subscribe to the channel. Let me know if you're a fan of Tupac, like on the real. I want everybody to know. I thank everybody who been actually tuning in. I thank all of the people who joined the channel. But this video gonna typically be about Keefe D and how he mentioned Snoop Dogg, Diddy, and Suge Knight name. Now Keefe D, he tried to yell out and he tried to say that Suge Knight was the one who paid him. Now, where did all this come from? Who actually knew that Suge Knight and Keefe D was working together? We all thought that P. Diddy and Keefe D was working together for this whole almost 30 years that had passed. R.I.P. Tupac. I would like to say by him trying to mention Snoop Dogg, Diddy, and Suge Knight name, it goes to show he trying to make them be the fall person. But tune in, listen to this, y'all. Like on the real, listen to what he said.
We're on for three motions. Let's start with the motion to sequester the jury. Mr. Stamp, did you want to be heard any further on that motion?
I mean, it's an unusual request in this jurisdiction with regards to sequestering any jury, but due to the level of media attention that we have on it, the fear and the danger is that the individual go home at night and listen to commentary, maybe not directly, but through family members, something along those lines. So we're always concerned about that. That's why we apologize.
I think sequestration worked pretty well when not everyone had a phone, but did absolutely everything in their lives attached to them. I don't know how we could
That's crazy.
Phones for an entire 30. We have to take them essentially to accomplish the goals of sequestration that you're laying out. Additionally, if we did that, then they'd be alone in a hotel room, no phones, away from their daily routines,
Right.
while watching TV, which would then have coverage. So my concern is that sequestration might actually not resolve any of the issues that we have. But I do understand the concerns while jurors are in the building, that there may be communication with people, so we could do some sort of like partial sequestration.
There's no case on point. There's no issue with regard to the Supreme Court, the United States or Nevada, that really sort of lent any type of real direction to the court to follow. I think at the end of the day, one of the things here is comparing what they're arguing to Diaz versus 8th Judicial District Court, which is 116 Nevada 88. The Nevada Supreme Court held that the waiver statute does not apply privilege in that particular case with regard to news shield statutes. And that was a case in which a journalist does not have to waive any rights or privileges by publication if they do publish. And so as a result, we're also arguing that it's the only direction that we have right now with regards to how the Nevada Supreme Court has viewed that particular issue. No Nevada Supreme Court or US Supreme Court cases directly address the proffer issue with regard to a promise or inducement to render a confession involuntary. The voluntariness of confession is determined by the totality of circumstances. I cite to Arizona v. Fulminante, which is 499 US 279. And I'm going to quote to it. It says, a defendant's confession is like no other evidence. It is probably the most probative and damaging evidence that could be admitted against them. And if it is a full confession, a jury may be tempted to rely on it alone in reaching its decision, while some statements by a defendant may concern isolated aspects of the crime or may be incriminating only when linked to other evidence. A full confession, in which the defendant discloses the motive for and means of the crime, may tempt the jury to rely upon that evidence alone in reaching its decision. There should be a huge red flag of extreme caution to the court with regards to admitting that kind of information in 2008, 2009. And that is, once again, Arizona v. Fulminante 499 US 279. We have a situation here where it's a 30-year-old case, it's a multi-jurisdictional case. There's a lot of things that were done in secret, and it's messy. The question is, at the end of the day, whose fault is that? Obviously, we're not law enforcement, we're the defense. Mr. Davis is a citizen wandering around in his life doing his thing. And in the meantime, as this is happening behind the scenes and under the table and in the water, there's movement, planning, things that are happening, discussions that are taking place to try to figure out, okay, how do we resolve this issue? And the problem is that if we keep Mr. Davis as someone that's responsible for this, for the messiness of this case, for that kind of thing, I think we have a huge issue, because I don't think it's his responsibility. We focus a little bit on this idea of, during the course of the time that he's meeting with these people, is that they threaten him.
Now, Keefy D, he keep trying to get out of this situation when he know what he did. Now that he older, he want to try to act like he didn't do that. You know exactly what part you played in the role of what happened to Tupac. I want y'all to drop down in the comments section, R.I.P. Tupac. Keefy D, he trying to get out this situation, and he bogus for even pulling that on Tupac. Everybody know exactly what went down and what happened. We know what they said. We know. I can tell y'all over and over again exactly what they said happened. Like, for real, man, I would like to just send my condolences out to Tupac, because he was the one had to suffer behind this. We knew how they tried to cover this up and tried to make it seem like it was something that it wasn't. This is something that it shouldn't have never got to this point, and Keefy D wouldn't have to be trying to plead itself in the court.
I don't know if the court received the thumb drives with the audio. Did you get a chance to review it? Okay. We gave that to the state as well. But with regard to the communication that's happening during this time period, it's pretty clear that Mr. Davis is being threatened. There's an understanding here during the time period that while he's in...
Are you referring to the Los Angeles or the Las Vegas? Or second?
So the 2008 would be the proffer that did not include Las Vegas Metropolitan Police. The 2009 is the meeting that Las Vegas had come down.
So when you're talking about threats, are you referring to Detective Kading in 2008?
This would be the 2008.
Okay.
And Detective Kading is one who mentions that, who talks specifically about it. And so let me just go through that part as well. The idea of Detective Kading, I think, is another problem. Now, Detective Kading, according to what the state has filed in their opposition, is that he's a private citizen, which I don't know. Maybe that was a mistype. It's pretty clear, Detective. You give me a look. Is that because?
No, you're fine.
I think at the end of the day that the idea of Detective Kading being a private citizen and somehow, and once again, this is in their motion. This is page 18. They say the following: Nevada exercised no coercive police activity against the defendant in connection to the 2008 proffer. No Nevada officer interrogated him. No Nevada officer threatened him. No Nevada officer made any promise to him. The Kading assurance came from a federal task force detective operating under a federal proffer arrangement to which Nevada was not a party. Connolly, which is the case that we cite here, that they cite, forecloses the defense's claim regardless of how the Basama factor analysis is framed, because the constitutional predicate for finding of involuntariness is entirely absent from this record. The only violation of his agreement was not by the government, but by a private citizen. And the only private citizen that we know that actually disclosed what happened in the 2008 meeting prior to a publication of a book or an interview done on a podcast or series was Detective Kading. And so, in essence, if that's what we're talking about here, maybe what they're saying is something else. But to me, the idea of a private citizen, if that's referring back to Detective Kading or anybody else for that matter, I think that that's erroneous. The law with regards to HAT, which is what the state has relied on in their opposition, it's under the Second Circuit. It's 884 F3rd 400. It's not binding legal authority. Now, it is still distinguishable in this case because even though Hack, the defendant in that case, was not in custody, detectives advised him of his Miranda. If you look at our case as a whole in totality, there's no proof at all. There's no recording, there's no discussion about Mr. Davis ever being Mirandized prior to giving any statement at all.
He's free to be.
See, but that's the problem with the analysis in terms of him being free to leave. If the analysis is he could have just walked in and said, hey guys, and then do whatever, walk out, sure.
But then it wouldn't have helped with his other situations. So
Correct. So now you have that problem of, hey, you leave, we're just going to arrest you on a drug charge, and we're going to arrest all your entire family, we're going to arrest everyone that's involved in this, and then now here you are. So Was he free to leave? No.
Correct, but he's also got his attorney, which, as we know from, law and order, is the second thing they say, that you have the right to remain silent, and you have the right to finish training. He has that attorney there, so it's not really this naive big what who can be overcome by these coercive techniques of the officers.
Yeah, but at the same time, though, once again, look, I could have been sitting next to Mr. Davies back in 2008, and if I know at that particular point, what's on the table is, if you leave the room, we're going to arrest you for drugs. What's my advice to my client? I mean, to me, at that particular point, it's like, hey, man, you got to do what's best for you and your family. You choose your path and where you want to go. And so as a result, once again, is that custodial? I think it is, because in essence, he cannot leave, because the threat is, you leave, we charge you and your entire family for drugs. That would be our position on that. Now, in addition to that, the other case that was cited by the state is Colorado v. Conley, which is 107 Supreme Court 515. The Supreme Court there held that, first of all, number one, a coercive police activity is a necessary predicate to determine whether a confession is not voluntary. Two, that the statements made by the defendant when he approached police and stated he wanted to confess to a murder, and then did so after receiving his Miranda, could be admitted without violation of due process because of his mental health. And then three, whether or not the state bears the burden of proof in a motion to suppress the statement already obtained by violation of the Miranda doctrine, the state only needs to provide proof waiver by preponderance of the evidence. Now, the idea behind that one is that it still doesn't fit the fact pattern in this case. That's why we're going back to the first problem, which is there's no precedence. There's nothing here to sort of say, hey, we have a framework, we have a previous situation that we can sort of use as direction in this particular case. In addition to that is that, in Conley, for instance, Miranda still was given. So even though it may have been late, even though the defendant in that case sort of admitted to the crime 5 minutes before being Mirandized, Miranda was a big part of the court's analysis in that particular case as well. So yes, even though client might be sitting next to attorney in the middle of a meeting, the process of the Miranda still takes place. There is still an advisement of the person that, hey, we're going to have a conversation here, and it might be against your interests. Now, is it up to the defense attorney to lean over? By the way, hey, you got a right to be silent. No, it's the responsibility of the law enforcement officers in that room to give that announcement to the client, which in this case didn't happen. And it goes back again to this idea of just being sort of like,
He's the client of their attorney.
oh, no, I'm sorry. Maybe I rephrased that wrong, but they're in there specifically for one purpose and intention. There should have been at least the idea of a Miranda. I don't know if that's this or not, but so on YouTube, I get a lot of YouTube reviews now. One of the YouTube things I look at, for some reason, the algorithms give me this, is police arrests for some reason. And every single time, they will immediately default back to the Miranda. Why? Because they need to cover that basis. Even if it's premature, whatever the case is, they want to make sure that whatever is going to happen here does not violate that Miranda right. And I think in this particular regard, you had some very educated people in that room. You had FBI, you had DEA, you had Compton Police, you had LAPD, you had a United States attorney allegedly in that room as well. And those people should have at least pointed and say, hey, just to cover all of our bases, let's just make sure this happened. And it didn't happen.
I did your research, nothing really like a similar situation where this situation.
Here's the best part about this. Yes, and here's the best part about this. At the end of the day, this is going to be a case that more than likely will be whatever is going to happen at the end of the day. This will be sort of that case. It will end up being the case in which the extent of how Miranda is used and the idea of when someone
or won't. So we have to make this decision with this trial. It's like,
oh, of course, absolutely. But I'm just saying, at the end of the day, with regards to this particular question would be the driving question here. If it does end up having to be revisited by an appellate court. In the future.
sure.
I just think that when we have a situation where you have multiple times MOG interviewing different people and everyone agreeing that, hey, yeah, we can't touch this, we can't get into this, we can't discuss this. Kading in the interview of this 2008 interrupts and says basically to Mr. Davis, what is said right here cannot be used against you, Keefe. Nothing you say today can be used against you, so don't even worry about it. And this is in a room with all these other detectives and people that at least at some point somebody should have said, I don't know, we're gonna run into a problem. Nothing like that happens in this case. We also identify in the recording as well, you know, that it was a discussion here with Detective Long. And his idea of this is like, he said, you know, this is like an informal meeting. He's just trying to get information. This is Higgins talking to the defendant. Now, once again, would I have said something like that? But people are telling my client, hey, this is not a big deal. We just want to get information. Then Long says in his discussion directly with Davis, you understand that? All I want to gather is some information. I have absolutely no intent of arresting you.
Yeah, R.I.P. Tupac. Everybody knew exactly what was going on and the reason why they did what they did. They put themselves in jeopardy. They put their lives in jeopardy. Diddy, he was the cause and the root of all this in a way, but I really feel that Suge Knight, he was the main one who got Tupac hit up. He was the one who sent them two dudes out there. He was the one that had Snoop Dogg scared for his life. Man, R.I.P. Tupac, man. Hit the like button, subscribe to the channel.